Mr. Jagdeo and the claim Mr. Jagdeo is challenging the validity of the final result declared by Mr. Mingo on the night of the 13th. And the basis of his challenge is that it was fraudulent. The figure that Mingo arrived at in relation to APNU and PPPC is different from that his statement upholds that he purportedly got from all the polling places in Region 4 different. So if Mr. Jagdeo issue is a question of fraud, then he's saying that the election was not lawfully conducted. And under Article 163 of the Constitution, it says anything that has to do with whether an election has been lawfully conducted or the result of the election has been affected by some unlawful act or omission, then it has to go to a special court, and you go to that court by election petition. So Mr. Jagdeo was trying to bring by way of the back door with something which could not have been entered by way of the front door. So that is why his application for disclosure of the statements of poll were not allowed. Section 19 of the National Assembly validity of election laws says when you are before the election court on an election petition, you can then apply to the judge for the ballot boxes to be presented to the court, and then they will open the ballot boxes and then go through all the polls. So the concern of Mr. Jagdeo can be addressed. This Constitution and the Representation of People Act and the National Assembly Validity of Election Act certainly set out the parameter which Mr. Jagdeo's concern can be addressed. In relation to whether this morning, whether Ulita Moore has jurisdiction to bring the matter, Ulita Moore has jurisdiction to bring the matter because they argued that it must become by way of an election petition, but the courts have admitted, notwithstanding that there is need for an election petition, you can come with an intermediate action seeking judicial review of an unlawful act that GCOM was involved in. For instance, Article 161B says no politician shall interfere. The politicians have no right to interfere with the supervision or the running of elections in Ghana. So that agreement between Granger and Jagdeo is ultra-virus Article 161B. There is a breach. They can't breach a constitutional provision. So GCOM doesn't have the lawful authority to accommodate an unlawful act. There is no legitimate expectation in Oladar and Jagdeo that GCOM will act unlawfully. Insofar as the application by Jagdeo and Oladar for judicial review of the second declaration and the refusal of Ramsey application for a recount, that is going nowhere. The judge will rule on that application because I applied to the court to strike that out. The court wouldn't have jurisdiction to hear that. Chief Justice in the first, Oladar and Mingo ruled on a limited way when I raised the issue of an election petition. She said there's only one way, one opening she can deal with is the issue whether the returning officer has counted the vote or ascertained the vote in accordance with Section 84.1. The evidence that were led showed quite clearly that they were not ascertained in accordance, because it's only 421 were ascertained and 558 was just thrown into. That's why she set aside that first declaration. But this second declaration cannot be set aside because Jagdeo and the PPP agents and candidates who were there saying the man did not comply with 841. Mingo and the election clerks said they have complied. So there is a dispute as to whether that occurred. And that dispute as to the counting of votes cannot be resolved by judicial review. It is the subject of an election petition. So all this issue has to be dealt with by an election petition. A stay was refused. Mr. Mendez was arguing that a stay will prejudice the people. That prejudice the people will have to go through if they lose. So if the successor goes into office and they succeed on the election petition, the successor will have to vacate and a new election will be held. Isn't that they will go to office, a new election will have to be held. So there will be no prejudice.
Well, the court, we had made two applications. One, that the court had no jurisdiction to entertain the Yulita Moore matter based upon Section 140 of the Representation of the People's Act, because Yulita Moore's matter essentially questions decisions of the Elections Commission. And Section 140 of the Act is very clear. It says that all decisions of the Elections Commission is challengeable or are challengeable, but only challengeable by way of an elections petition. That is opposed to a decision of an officer within the Secretariat, as is the position of the returning officer. What Yulita Moore is questioning is decisions of the Commission, and that is what the law says should only be challenged by way of an election petition. The judge didn't accept our argument and ruled that he had jurisdiction to hear the matter, the substantive matter. Then we had made an application for discovery for the copies of the statements of poll within the possession of GCOM to be given to the court so that the court can have that assistance in coming to a conclusion. The court ruled that you can only get SOPs through an elections petition. So he overruled that application of ours. But most importantly, the substantive matter is still there in Yulita Moore's case. And we also have an action there that has not begun to be heard as yet. That is the matter filed by Jagdeo and Holidar. And importantly, what I should highlight is the chairperson of GCOM's submission. That came in yesterday afternoon. And I have been very critical of the chairperson's position over the past few days. And I must say that in these submissions, the chairperson of GCOM has finally assumed the role and has indicated in those submissions that she is prepared to discharge her duties under the Constitution. She said a couple of very important things. One, that GCOM is the body that is in charge of the electoral process, and that Yulita Moore application should not be granted because it would force GCOM to make decisions that are not truly GCOM decisions, that GCOM has made a decision already that a recount of the ballots should take place, that GCOM has drafted an order to send to be gazetted, and that she intends to give effect to that decision of GCOM, that she has given an undertaking to the court to that effect, and that undertaking is in the form of a court order or is like a court order, that it is imperative that GCOM be allowed to carry out that recount, that CARICOM, while CARICOM was to assist in the the carrying out of the recount, it was not CARICOM's decision to do the recount. It was GCOM's decision to do the recount. And that she said also, quoting Madame Desiree Bernard, in Aubrey Norton case and in Joe Hamilton case, that it is imperative that trust and confidence be continued to be reposed in GCOM, and that GCOM must do everything to dispel any lack of confidence and any perception that GCOM may not be acting fairly, and that GCOM has all the powers under Article 162(1) of the Constitution to correct any errors that any RO may have made in relation to recounts and the refusal for recounts, and that GCOM is poised and is ready to carry out the recount that GCOM decided upon on the 15th of March. So those are very positive submissions made to the court by the chairperson herself, and I believe it can lend, or it will lend a far way in resolving the dispute. Because the dispute essentially is, should the recount not be granted, having regard to everything that has transpired? Or are we going to use the court as a legal cover to not to do a recount, when everyone is requesting a recount, and a recount is a mandatory facility available at the law or by law, and a recount would address definitively all the matters or most of the matters of controversy. Whether a court rule that a recount should take place or not will not remove the stigma that has already been attached to these elections. The declarations of Mr. Mingo made on the 13th will not be accepted. It has been rejected by the international community and by the local observers and by the political parties contesting the elections. So the issue is, would one use the judiciary now to give legal cover to what has no social acceptability and no political acceptability? So that is the issue that one has to deal with at this point in time. But the case is there, and we are going ahead with the case. In terms of the decision, whether the court has jurisdiction or not, we have signaled an intention to appeal that decision, because we believe that the learned judge fell into error, and we will prosecute our appeal to the very end.
We are to the full court first.
Well, the law says that we have to go to the full court, and then to the Court of Appeal, then to the Caribbean Court of Justice.
How soon will you be doing that?
Well, because of the exigencies of the situation, obviously we have to move with every convenient speed. And we are working on that right now as I'm speaking. There's a lot of work that has to be done, but that is what it requires, and we will proceed with it.
Even though the assurances were given by the chairman in her submissions that were the recount and all of that?
Well, unfortunately, the judge has not reached that stage. I was hoping that at some point in time, the judge would have used the occasion, because we have to understand that this is not only a legal case. This case has ramifications and has consequences that are far beyond the judiciary. And a judicial decision that is not reflective of the expectations of the people will only compound the problem. It will not solve or address the problem. And I thought that perhaps the court, in its wisdom, would have looked at, perhaps the court has not seen the chairperson's submission. I'm hoping that that is the position, because it did come in late yesterday afternoon, and perhaps there are huge sets of submissions, and perhaps that has not reached the eye of the court. Once it reaches the eye of the court, I am hoping that the court can have pay attention to that, so to speak, because I can't also direct the court on how the court should conduct its affairs. But one would expect that if such a position presents itself from the chairperson, and it's not only the chairperson, but a person who has a casting vote and who can bring this matter or these matters of controversy to an end, and she has said so in her written submissions to the court, I am hoping that the court, at the earliest opportunity, will act upon those submissions.